Welcome back to the second part. Now we will deal with the topic of intellectual property management. As you were able to observe, in business practice, there's a large number of different protection instruments with a wide range of functions. As you will remember, we were talking about protection, about blocking of competitors, we were talking about reputation, and so on. And they all have specific advantages and disadvantages. In addition, for the appropriation of returns on innovation, there are different appropriation mechanisms available. And they as well have specific characteristics, and their use requires a systematic combination with the respective protection instruments. However, the mere creation or existence of intangible resources, for example, in the form of a promising invention or an innovative product design, is just as little a guarantee for success for a company as the mere use of protection instruments. Most important is the effective and goal-oriented use of the intangible resources available, which also includes strategic considerations. This insight leads to a demand for a systematic and economically oriented IP management. Because in order to achieve the company's objectives, intangible resources, just like other corporate resources, have to be managed and used efficiently according to the business management criteria. Only then the company will be able to use them to their full extent. So this raises the question of how an IP management should look like. Before we explain how IP management should look like ideally, let's first discuss the typical problems and shortcomings of intellectual property management on the corporate side. Usually we have scarce financial resources, and these are used to promote the own core business. That's something quite normal. And many companies focus exclusively on their own core business and core competencies. That's also pretty normal. They develop a kind of tunnel vision, and very often they completely forget to take care of other important issues, like IP. And very often you will not find any employees that are qualified with IP. So we have no qualified IP staff. There's a lack of employees with appropriate training. And in addition, we have a lack of knowledge and organizational structures inside the company. You will find that very often if you go into detail. As a consequence, there's either no IP strategy or no protection at all, or even if an IP management is existing, we often observe a one-sided focus on patents. That means protection focuses only on technical components, the invention itself. We can find that this is very common in business practice. In this case, intellectual property management is just a byword for patent management. Of course, protection of the invention by means of patents is not fundamentally wrong. However, it may prove to be insufficient to limit protection exclusively to technical functional features of an innovation. What if the innovation to be protected does not fulfill the corresponding protection requirements? However, even if it is possible to apply for a patent, the one-sided focus on the protection of the technology can sometimes prove to be inadequate. Let me give you a short example. Imagine your company develops a product innovation that is based on a technical invention. A patent is granted. Subsequently, in the course of the market launch, the company is investing large sums in advertising and other marketing activities. The new product becomes a success. After a while, a competitor decides to launch a similar product with a similar or even identical external product design, but with a different functionality that is not based on your patent. Therefore, there is no patent infringement. As you will know, a lot of Asian companies work like this. The example given is just illustrating the inadequacy of a mere protection of the invention. For this reason, a change of perspective is needed. From invention to innovation, we need an IP management approach that takes into account not only patents, but all protection instruments and their functions. This means we have to give up the predominantly inventory-oriented protection strategy in which the choice of the instruments of protection is based exclusively on the underlying technical solution. We need a change of perspective because this one-dimensional perspective must be abandoned in favor of a holistic view that focuses on innovation as a whole, which is to be understood as a bundle of technical and non-technical components. As you can see here in the figure, we do not only have our invention, the technical functional features of the product interior. We also have non-technical components like product appearance and additional services. We can use the wide range of product dimensions to start from when we talk about protection of innovation. For example, the product appearance. External aesthetic appearance of a product including its packaging or symbolic product features like brand names. And we also have additional services, so-called value-added services like customer service, product-related manuals, plans, or design drawings. The change of perspective from the individual invention to innovation as a bundle of technical and non-technical components thus show further links for protection and makes clear that protection of intangible resources is not necessarily linked to technical functional product features. With the consideration of these further product dimensions, further protection instruments suddenly become accessible to the company. And the individual components can be used as possible starting points for protection instruments like trademarks or industry designs. A really great example of a holistic intellectual property management is the company Vorwerk. They have protected the Thermomix all around, and not only with patents for their knives, for the aroma extension, for the locking mechanism, and so on. They also have design patents, designs for the protection of their external product design. And they have copyrights and database rights to protect database compatibility. In addition, they are using trademarks a lot. They have three-dimensional trademarks, figurative trademarks, and something that is very unique, except for telecom, I do not know a lot of companies who have a sound trademark. Maybe you will have heard this sound. Thermomix makes this sound in the end of preparing a meal. And a lot of people tell me that they want to hear exactly this sound, that this is the original product sound. Yeah, and maybe you have asked yourself why the Thermomix is so successful, even in Southern Europe countries where they sell a lot of Thermomixes. And the price level, you will know, is very high. The Thermomix is very expensive. Maybe that's the reason why I do not own one. But as you can see, a lot of people want to buy a Thermomix and they are ready to spend a lot of money for it. And this is the result of a very good marketing, but also it is the result of a very systematic and intelligent IP management. This example shows very well how a certain product can be protected multidimensionally. This holistic approach is also applied in the commercial vehicle industry. Wirtgen, for example, once protected its tracked vehicles by means of three-dimensional trademarks. Companies like Claas and John Deere also use registered designs. The importance of product design as an essential success factor and link for protection can also be observed in other industries. On the left side, you see the Smart 4.2 and its replica, the Shuangwang, I cannot pronounce it, an Asian car. And have you ever wondered why you don't see this car on European streets? Well, one of the reasons is that here the exterior product design is protected by registered designs. These give its owners similarly strong rights as a patent does. With a registered design, you also have the right to exclude others from using the design. And this intellectual property right is much cheaper than patents. You should always keep that in mind, that the small intellectual property rights also give you an exclusive right, but they are less expensive. Therefore, you should consider them. The situation is similar with three-dimensional trademarks. Lindt, for example, you can see it on the right side, defends its golden rabbit very aggressively against other competitors who are pushing into the market with similar products. For example, Hauswirt had to remove all its rabbits from supermarket shelves because a court decided that there was a likelihood of confusion with Lindt's product. The Riegelein case, on the other side, shows that intellectual property rights are not always a guarantee for success. In this case, Lindt lost and Riegelein is still allowed to sell its golden foil wrapped rabbit because the courts decided that there was no likelihood of confusion. You can see from this example that the whole thing is quite complicated when viewed at it in detail. It is clear, however, that the ownership of corresponding intellectual property rights is not a disadvantage from the owner's point of view. So how is IP management to be defined? What is it? What is IP management? It is important to note that IP management is not about protecting inventions, at least not primarily about protecting inventions. It's not about protection as an end in itself. IP management is about maximizing the success of innovation and, of course, of the company by optimizing appropriation of innovation revenues. So it's about to create the conditions for the appropriation of innovation revenues. That's a very huge difference to the idea of just seeking protection for a single invention. So how should an IP management look like? Which characteristics does it have? In practice, you will very often find companies and their people talking about intellectual property management. But in fact, most of the time, they are actually not talking about IP management, but about patent management. And as I already mentioned, it is crucial to abandon this one-dimensional approach, which only takes into account the protection of technical characteristics. Instead, a holistic approach is needed. Holistic in a sense that the approach takes into account all the protection instruments available to the company, legal and de facto ones, and without a priori giving preference to any particular instrument. A systematic and superior IP management should therefore not only be holistic, as we already mentioned. It should also be value-driven, integrated, process-oriented, and interdisciplinary. Value-driven, that means all IP management tasks have to be aligned to maximize innovation revenues. We will talk about this in more detail on the next slide. Integrated, because the overall IP strategy needs to be aligned with corporate goals, innovation strategy, the market, the competition, the competitors, and also the character of the product. Process-oriented, because we need to define clear processes. We need to define who is responsible for what. We also need to define process objectives and budgets for successful IP work. Interdisciplinary, because IP must be considered holistically. It is very important that we combine different motives for the creation of IP, different protection instruments, and also different exploitation opportunities. They all must be considered and linked with each other. Let me please explain to you very briefly why IP management must be value-driven. Because at this point, I would just like to go into more detail about this characteristic. So IP management, a systematic IP management, has to be value-driven. Because, like I just explained, the aim of IP management is not primarily to protect the invention, but to maximize the innovation revenues by optimizing their appropriation. This is what you already know. And to do this, we have to create exclusivity, for which we use protection instruments. So, as you can see in the figure on the left side, what is happening without exclusivity? Without exclusivity, we observe an average profit. When we manage to have exclusivity through IP, it's becoming way better because we can partially exclude others from using our intangible resources. But we're still lacking a systematic management. And with a systematic management of intellectual property, it will be possible to generate defensible, exclusive, and sustainable additional benefits. So we can have premium prices, and an increase of the market result will be achieved more easily. So there are 3 more characteristics left. Besides being holistic and value-driven, a systematic IP management also needs to be integrated, process-oriented, and interdisciplinary. Based on the existing technology and patent-driven processes, IP is integrated into other processes such as innovation, information, and marketing processes. The central IP process is essentially carried out by the company's own IP department and, if necessary, in cooperation with external IP experts or patent attorneys and, of course, with the inventor. Traditionally, there is a close connection between patent work and the R&D department, and very often we observe the phenomenon of decoupling from the rest of the company in a kind of isolated operational island. The IP people are doing something, no one knows exactly what they are doing, and they are far away from other organizational units. This effect can be overcome by integrating IP management into the adjoining corporate functions. Furthermore, an integrated IP management is an originally interdisciplinary field of activity. IP work is an interface issue that requires intensive cooperation between different business units. In practice, however, communication is often limited to the exchange between the IP department and the research and development department, which communicate via invention disclosures. In contrast, a modern IP management integrates in particular those departments that are close to the market, like marketing, sales, product management, business development, and so on. And they do it in order to align IP consistently with the market, especially with customers and competitors. The cooperation of many players require the commitment of the high-level management. From my personal experience, I can tell you that without the commitment of the managing director and the high-level management, it is just not possible to implement a systematic and integrated IP management. I would like to talk about ensuring of freedom to operate in more detail. You should always keep in mind that your own results of research and development may infringe the intellectual property rights of a third party. If it does, this causes high costs and it's sometimes threatening the existence of your own company. And you should always keep in mind that there are companies that normally neither carry out research and development nor produce anything, but generate their income by exploiting intellectual property rights. We're talking about IP trolls, about patent trolls, maybe you have heard. These should be given as little room as possible by actively taking care to avoid intellectual property right conflicts already during the development of new products. This is called product clearing. You should do that as well if you introduce new products. Start with a product clearing. It's very important. Especially startups often violate trademark law because they avoid the topic of intellectual property rights. They start with a brand name, not knowing that they are infringing someone else's trademarks. With Beyond Innovation, we had a case where a manufacturer of salsa sauces already had labels printed and advertised with a name and so on. However, he had never thought about whether third-party rights are existing or not. For example, whether his trademark might infringe the trademark rights of third parties. He had not even applied for a known trademark, but he also did not check if there's another company who owns a trademark. Shortly before the market launch, it turned out that a French competitor owned 3 identical brands, and so the market entry had to be postponed. The already ordered packaging could also, of course, not be used, the company name had to be changed, the customers had to be informed, and so on. And that all in all led to an enormous sunk costs. But all this was even better than having to bear the costs of trademark infringement, because infringement and legal costs quickly amount to several thousand euros. So please note that it is extremely important not only to protect own inventions, but also to avoid collisions with other in advance. As you can see, there is a lot that can be done wrong, especially when it comes to trademarks. This is also shown by a case that I want to mention here. This is Ushi Company, and they are selling women's clothing online under the brand Ushi. At least they did. Because in this case, the owner of an earlier trademark enforced his rights so that Ushi had to rename its company to Ouya. This was of course a major setback for the business development. And as a result, there are often enormous costs involved in opposition actions, cancellation actions, or actions for injunction. But above all, it is the soft costs that can be extremely painful in such cases. This includes, for example, changing the company's name or the product names or other things. If you only have a web shop, it may be not a big deal because you can quickly rename your web shop in the event of a collision. But previous expenses for advertising have then been in vain. In addition, a new brand must first be developed and made known on the market. This is something that you had done before, and you lose it because you have to rename your company now or your product. And if you have a large illuminated sign, for example, with your name on it, or 3 containers of goods from overseas, they are on their way to your company and the name is attached to each product, then the potential damage can be existence threatening. This is because you're not allowed to sell your goods and services under your trademark's name. Just as painful is certainly the irritation that is caused to customers and partners. So, if you add it all up, there are essentially 2 reasons why every company has to deal with intellectual property. And this is also a reason why they apply for intellectual property rights. First of all, they want to prevent imitation. And on the other side, they want to ensure their freedom to operate. Let's start with the right side, prevent imitation. We already were talking about this. We are basically talking about that all the time. Protecting your own innovations from being imitated by others. Intellectual property rights will keep potential competitors from directly copying one's customer offering. And IP protection is also needed for alternative implementations. Apart from direct copies of the offering to customers, however, one also wants to prevent competitors from finding options to design around and thus offering customers the same benefit or something confusingly similar. So it's necessary to think carefully about what ideas competitors might come up with, and to protect these implementations for oneself through all forms of IP rights. Protection here is also is not about actually implementing these ideas oneself, but about keeping others from doing so. So in your case studies, maybe think about what would be a suitable and efficient IP portfolio. Think about the IP protection for the intended implementation of your own business model, and also think about protection for alternative implementations of your business model. The second reason is that the company wants to ensure its freedom to operate. This is about ensuring that the owned products and services do not infringe any third-party rights. These activities are a prerequisite for being able to operate the future business at all. To ensure the freedom to operate, first of all, you must check for all relevant countries whether implementing one's future business model or one of its alternatives will infringe any IP rights of third parties, such as patents, utility models, designs, trademarks, or copyrights. All in all, a complicated but necessary task. If the implementation is not free from third-party rights, then a remedy must be quickly found, and there you will have two basic approaches. You can change your own approach, or you can get a license or buy the intellectual property rights of the other company.